You have made an offer of proof, and as long as we can determine, because as much as I'm telling you all our don'ts, we do try to reach the merit of a case as much as possible. So if we can reach the merits of the case without advocating, we will do it. But it's certainly necessary to, and you should, make an offer of proof. Now, how you make your offer of proof, I'm going to tell you just to make sure that in that offer of proof you have stated what it is that you find error with the judge as far as why it should be sustained. So if your objection is going to be irrelevant, and these two judges say sustained, when you make your offer of proof, after you say what the witness is going to say, you need to state why that is relevant. And then we're going to say he preserved it. Even if you ask for a running objection, then we could say he preserved it.
So with David's question, there's not a distinction between the lawyer making an oral offer proof of what a witness would say versus putting on the witness directly. No. There's not a distinction in your mind.
No, not for purposes of, we prefer you do it, putting your witness on the stand, but remember, we're court of error, and it has to be prejudicial error, not just any error. So the fact that you have chosen to make your offer of proof by stating what your witness would testify as opposed to putting it on the stand isn't going to affect how we look at the facts to see if the court erred, not the lawyers, the court, in making that determination.
Thank you.
I will tell you from my perspective, Counselor, that at the trial level, I believe you're better off putting the witness on the stand and asking those questions from this simple perspective. I presume you and I have already had a sidebar. I've heard your argument and I've said no. So what you're really doing is just retreading that. I'm sitting on the bench now on the record formally telling you no a second time. Recently I had a situation where we did the offer of proof. At the end of the offer of proof, I actually allowed the evidence to come in. It would not have come in short of the witness testifying had the attorney stood in front of me and just retreaded the same old argument. One thing I do want to comment on, since we were talking about some discovery and pretrial rulings, remember motions in limine preserve nothing. So if you have a motion in limine ruling, you still need to get those objections on the record during trial because you've preserved absolutely nothing with your in limine order.
And let me just say this. Of course, I describe my division as the marketplace, what the market may bear. And you say, well, Judge, what do you think? Should I do an affidavit or should I said, proceed. Do it however you want to protect your record, but you got to make a record. I'm not going to say that, but in fact, I'll even note that the objection is ongoing. Failure to make the objection will not be waived, even I'll assume they made it at the appropriate time without waiving same. I'll try to protect the record for that. But how an attorney wants to do that, that's that attorney's work product. And let me just say this. We've had an attorney that stood a little bit too close to the jury one time, and like My Cousin Vinny, the movie, the jury handed the paper over to the bailiff. They handed the paper during the course of trial over to me, and they said, "Dear Judge, we would like you to find the attorney in contempt of court and throw him in jail." And I looked at the attorney and said, "Court will be in recess. Let's go in chambers and talk about this." And counsel, I think you're a little bit close to the jury. And his associate stepped forward and said, "Judge, we can stand anywhere we want to." I said, "How do you figure that?" He said, "Oh, my law professor said," and I don't remember anything else he said after that. I said, "Look, stand inside the jury box, all I care, I really don't care. The jury is already conveying a message to you. This is the marketplace. If you want to do," he didn't stand in the jury box, no. But, the case could have been settled for $50,000, maybe $30,000 early. Jury put a $1.1 million verdict tab on that verdict. And that's how they showed that they didn't like the attorney standing too close to them. So, it didn't bother me. So an attorney, yeah, you've been through the courses, you've been through law school. It's your presentation that counts in front of a jury. I'm not going to get in the way, and if you wanted to preserve the record by putting your live witness on, that may be a good idea on those little things that you may forget to ask that's in there that may come out, because if you put it on paper or if you put it, something might be missing. So, but I will not suggest to the attorney, the only thing I'm going to say is proceed, and good luck with an appeal.
Make your objection or your points. Make sure you have stated it in your motion for a new trial or motion for judgment notwithstanding the verdict so that it is preserved. Our jurisdiction derives from that of the circuit court. And so a lot of times people resolve things by motion, and I know it sounds trivial, but the Supreme Court has spoken. And you get an order from the judge, and it's not a denoted judgment, not a judgment. We don't have jurisdiction over it at the Court of Appeals. A lot of times, judges, you have a case that all of the facts are intertwined, and if you don't get rid of a judicial unit that is separate, sometimes you guys want to appeal it right away, and the judge will put no just reason for delay. Just because he puts those magic words down there doesn't mean that it's necessarily right for us to review, especially if the judge hasn't dealt with one of the judicial units that are separate from the rest of the case. So be mindful of that. Another thing is, a lot of times when people argue, they argue about exhibits, like our evidence was shown in Exhibit P that was offered and yada, 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 and they talk all about Exhibit P, and you don't put it in your appendix. We're not going to take a 2-week trial, which is voluminous in records, and go search to look for your Exhibit P. If Exhibit P is important enough for you to rely on in your argument, make it easy, not that we're lazy, because we do still look at the record, but make it easy for yourself and attach it to an appendix. That appendix will save us a lot of time, and it will carry a lot of credibility with you along the way, especially with instructional error. A lot of times people will offer an instruction that the court refused, and then they forget to give us the refused instruction. Can't look at it, we don't have it in front of us. And they also fail to say what the refused instruction said in the argument. It was just that it was a refused instruction, and it added an element that wasn't there, that wasn't required for plaintiff to prove. Okay, that's all great, but we still need the instruction in order to do it. Now, it is incumbent upon the appellant to provide the court with all of the documents that's needed to resolve the issues on appeal. And if you don't attach something for us, then we're going to assume that it was favorable and would have been against you. So if you're going to file an appeal, please dot your I's, cross your T's, and I'm telling you, Rule 84 really does set it all out for you. And if you follow it, you won't have any problems with your appellate review. Yes.
My question is for the trial judges. Judge Dowd recently, this month, talked about how an attorney should act and represent his client, and he said the dog-eat-dog world, that in representing zealously your client, you don't need to be civil, in essence. And so I'm wondering, when these opinions come down, whether or not that changes your approach to attorneys at the trial.
Oh, well, okay. In here, in the survey, it calls why zealous representation does not mean torching your adversary. And they look at a lot of things and what may be the limitation. But if I had a case, and if the attorney wasn't doing anything for his client, then I would be concerned about that, because if you want to say, what do I expect? I expect there to be some kind of advocacy, some kind of, if you want to say, fight for his client. I've had a fellow church member that dumped his client like a hot potato, and I had to kind of complain about his ethical conduct and sanction him for that, although he was a fellow church member of mine. Didn't want to do that. but he was not doing anything. And I don't want an attorney to just sit there. I expect something. But what will happen if they just sit there? I'm not going to get involved in the arrangement between the attorney and the other attorney, or whatever is going on. I'm going to rule accordingly. But you know, if that attorney gets up and starts screaming and yelling and doing all kinds of things, I'm not going to mention his name, but I've had a talk with an attorney that his policy was doing exactly that, fighting. And I said, when are you going to get tired of doing this? You're just trying to wear out your opposing counsel. You know, you're not doing anything unethical, but I can see your strategy. But can you try to accommodate, at least try to get this case done on a professional level, a little bit higher than what you're doing? You know, I don't want to take both of you out in the courtroom and scream at you. And he changes whole conduct. But that's what the market will bear. If you have an attorney that has that strategy, it's going to backfire sooner or later. We've had an attorney, you know, and this attorney treated a lot of her opposing counsel very poorly. And I said to her, obviously one of us had too much coffee to drink this morning, and I hadn't had my cup yet. She said, that's unethical, Judge. I said, oh, what is that unethical? So, and you had a whole law firm fighting her. And I tried to, I even wrote her instructions for her for the jury trial. And then she found out, and I said, you know, you got to be careful in front of this jury. You know, you're grinding your teeth at the opposing counsel, but you're smiling at the jury. The jury is looking, they're laughing at you. Juror number 8, juror number 4. And then she goes out there on the record, says to Judge, let's put this on the record. I said, oh, in front of your client? Sure. Juror number 8 was doing this, juror number 4 was doing this. And then she realized everything was collapsing on her. And then she said, right in the middle of a jury trial, motion for a settlement conference. And I said, what? You know, I said, I never heard of that, but I looked at the opposing counsel, well, what's your position? I object. I said, sustain. We're out in the trial. But, you know, I tried to pull her in.
Preserved.
Yeah, it wasn't preserved. It was in chambers. But I tried to, but you know, I can only do so much. It's the marketplace. If they're going to be this bang, bang, you know, you have to judge whether or not you're turning the judge off, or the judge is eating popcorn and soda and say, yeah, let's do this. Like some judges, you know, encourage, like, yeah, I like to see that action. You're going to have to use your own judgment and discretion on what to do. I can't get in there and say not to do something.
Judge Vincent or Judge Reuter, from a practitioner's point of view, if you're dealing with a combative lawyer and you think they're the bad actor, how do you handle that on the other side? I've had other lawyers like that, and because you know it's that Mark Twain quote: "They'll bring you down to their level and beat you with experience." If you argue that, you tend to sound like you're just quipping with each other. And so how do you rise above that? How do you deal with that type of practice against you when you don't want to be dragged down to that level? Any good techniques you could offer us?
In the family law context, I think there's really two sort of moving dynamics for me. The first one is we currently live under a very broad discovery rule. And a lot of those arguments that occur in front of me generally are revolving around this discovery is too broad, et cetera, and one side feels they're being attacked. Generally, I will follow that civil rule, but keeping an eye on, in a family law case, I can award attorney's fees. And at the end of the day, you as the practitioner may have to stay in the muck and just deal with sifting your way through discovery. But if we try the case and the issue of attorney's fees is in front of me and I find that one side was overly aggressive and was abusive with the rules or have taken liberties with the rules not in proportion to the case that was in front of me, that is how I can handle it. I can start adjusting by awarding attorney's fees one way or the other. I would like to touch on Mr. Wiseman's question. It's a real fine line, I think, between being professionally courteous and zealously advocating your client. And you truly do need to know your audience. I think in a judge-tried case, I can tolerate a little bit more behavior, one, because I was on the other side of the bench and was subjected to that same type of behavior by counsel from time to time. And I have the ability to, once we're off the record, digest the case, look at the law, look at the facts, come up with what I believe is the right ruling. In a jury-tried case, any element of buffoonery can be fatally distracting to an attorney. And the side that is engaging in that behavior may then touch on 10 or 12 laser-focused points that are extremely relevant, right on point, but are lost on the jury because people get hung up on that type of behavior. And for those of you who have bothered to poll your jurors after cases, I tried a handful of jury trials in my time as an attorney, and two of them, more of the jurors commented on, well, I really didn't like the attorney who was representing the other side. I mean, these activities can at times drive the result of the case.
I was 17 years as a trial judge, and I don't even know that he's here. I don't know if you guys know him, but it's Shaprizi. Tell him that I gave him a plug because he did a good job. But he was trying a case in front of me, and he was dealing with a lawyer who wanted to make disparaging comments about the case and about counsel, and it got ugly. And the first time it happened, I politely said, and so that I wasn't addressing the one particular lawyer, but in general, I said, gentlemen, the only person that gets to be rude and uncivil in this courtroom is me, and I never do it, so I don't expect counsel to behave in this manner. It went on. The particular lawyer kept doing it, and Shaprizi was the epitome of what Michelle Obama said when she says they go low, we go high, and he kept doing it, and he said, well, Judge, sometimes it's not necessary for me to address those things that are not part of the case or that are degrading. So I am just going to tell you why my position is here. And he addressed the guy in a nice way and then said, but here are the facts, here's the law. I mean, you know, to me, that was some asterisks over here on his side, because he could have gone low and been just as disparaging toward other counsel and called him out his name, but he chose not to. He said, it's really not about my personality. He may disagree with me, Judge, but here are the facts of the case, and here's the law, and I'm not going to answer all of his negativity. I'm just going to address what's important to my client, and he proceeded with his argument. So you don't have to address all ignorance with a remark. Sometimes ignorance is bliss, and it's best not to try to address it. Focus on what you're in front of the judge for and win your case for your client, because he certainly lost a lot of brownie points in trying to make it about the personality of Shaprizi, but he did an excellent job of diffusing it.
And I'll touch on it again, what I said earlier. I live now in a world of discretion. When that behavior is going on in front of me, don't turn around and ask me to use my discretion to your benefit, because that may be how, to answer your question, Mr. Berger, that may be how I resolve some of that behavior in front of me.
And let me just make one point clear. Judges talk to each other.
Just like lawyers.
Yes, and they know who to expect and what to expect. And how I do it is just by reputation. And I'm sure you watched the movie My Cousin Vinny, one of my favorite movies. And no, I'm not that judge. You know, I don't do attorneys like that. But we did have one attorney, and I asked a question to his client in the bench trial, and he instructed his client not to answer my question. And I said, oh. And so to make a record, it's like you do in deposition, sir, did you hear my question? Your attorney instructed you not? And if you don't answer it, that's okay with me. You know, but did you hear the question? Yes. Are you going to answer it? No. I said, that's fine. Step down, because I'm striking your entire testimony. And the attorney said, you can't do that. And for my 20 years plus of being a judge, that's the only time I used a gavel. That gavel came down very hard. And I said, counsel, don't you do that. I'm going to give your client 5 minutes to determine whether or not he's going to ask it. If he does or doesn't, that's fine. but court will be in recess. And that gavel came down again, and I think I tripped over my robe because that's how the door slammed to the clerk's office. That's my story, I'm sticking to it. But the attorney, very apologetic, and it doesn't bother me, came in and said his client's going to answer the question, you know. And he said, but just go ahead and ask it again. I said, you still don't get it. I asked it once. I'm not going to ask it a second time. Is he going to answer? Yes, sir. So by reputation, a judge, you know what a judge is going to do. And that's the only time I've done that. Okay, of course, that's the only time some attorney instructed his client not to ask my question. So, but by reputation, you have to know who the judges are. Remember the first thing I said while I was in here? You got to find out who they are. You got to talk to your colleagues who've been in there. You got to talk to the clerk. The clerk is an excellent person. He or she can tell you exactly the quirks of all the judges out there, some even by nickname. So, but I think that's how a judge controls behavior in her or his courtroom. So.
I would say you're wasting your time with those type of behaviors at the Court of Appeals because you only have 15 minutes and 3 minutes in rebuttal. So if you want to waste your 15 minutes being a buffoon, oh well, or being ignorant, oh well, you're not aiding your argument. I would say, use it wisely. You have some points that you're trying to bring out. I would say if you have 13-point appeal, obviously your 15 minutes, you're not going to be able to argue all 13 points. But I would certainly say take those points that are the strongest for you in your position that are winnable and talk about those as opposed to talking about counsel or why the judge was crazy for making the ruling that he made. It won't gain you any points in your 15-minute argument.
And it won't gain you on paper, too. If they do that on
Certainly
paper, the
doesn't.
same thing, I would assume.
Certainly doesn't gain you anything on paper. And certainly it also hurts you because if you didn't do something correctly, you do have discretion too when it comes to ingratia dealing with cases on the merit where briefs are deficient. And I don't know how much latitude you're going to get if your brief is bad and you're making disparaging comments about counsel and judges and everything. We can dismiss the appeal and we would have authority to do so.
Any other questions?
You like a question?
Yep, David.
I have a real quick one, and I appreciate you folks coming up here and providing your insight, and I'm asking this knowing I don't have a case in front of either of you right now. It happens occasionally in a case, and not very often, that you have a motion or an issue that has been fully and well briefed and argued, and then nothing happens with it. And I know y'all are busy. There's no question. Everybody's working hard to get things moving. But what's the best way to approach a judge when you've got something that in your mind is integral to the case? I had a very wise lawyer told me when I was very young, be careful what you ask for, you might get it. So how is the best way?
Motion it up for hearing.
Well, yeah, I think you're probably talking about post-hearing submission.
No, I'm talking, well, yeah, it
Right.
could be simple as a motion to compel discovery response.
Right, but by way of rule, and everybody knows this, that we've had the electronic filings. Things disappear. And I tell the attorneys, the only thing I have is a clerk's note or a memorandum in front of me that says this is under submission. Do not be afraid to contact the clerk to say, hey, wake that judge up, get this going here. You don't have to leave your number. You don't have to leave. It doesn't matter to me if, in fact, I think the last attorney, I don't know if I was waiting for something and we do not get the electronic submissions right away and they need to alert the clerk. He alerted the clerk. Not only did I issue the order, it was in his client's favor, but I also put down there, reading the motion, that I said this is subject to attorney's fees. So you need to, subject to leave granted to contact the clerk for another date for a further hearing. To me, I don't penalize anybody of course, you may have some judges, that, who called, what's the license number and all this? You know, I don't think so. I think, yeah, it would be, I think all the judges would say, or most of them would say, it would be very helpful for attorneys just to remind us. A call, email, or what have you. Not necessarily email unless you CC your opposing counsel on the same email. But that's okay with me because this electronic world is, our files disappeared. And you know, I'm not complaining too much because I happen to be an electrical engineer. So, but I thought I got rid of all this technology by going to law school. Apparently not. So.
Well, certainly you don't want to wait till the 95th day because after 30 days it's deemed denied. But I don't think any judge would be upset if you called up your motion notice up for hearing, or if you called and reminded them, hey, Judge, you know, we've already heard this, a 90-day clock is ticking here. Can I get you to rule on this motion? I don't think you're going to run into any problems there.
I would concur. I think you need to know the judge you're dealing with, but I've never been offended by a friendly nudge. In fact, in family law, the divisions were generally very clogged in every courthouse that I practiced in, and there was a unique, or I think a unique appeal situation with a lot of family law cases, that if a judge tried a case and sat on it for too long, it was almost a slam dunk appeal to appeal the fact that they sat on it so long that now all the figures of the estate have changed to the point that the evidence went stale and we have to retry it. So in the family law world, we would, if we were in that situation, go as a team to that judge and give them the friendly nudge by saying, you're kind of butting up against that ruling, and boy, neither side really wants to appeal this and win easily on the fact that you drug your feet so long that now all the IRA figures have changed and we're going to retry the case. And most of the family law judges that I practiced in front of, do not want to be overturned on appeal, and therefore we're appreciative of the fact that we were giving them that nudge, because frankly, a lot of them were focusing on the high abuse case load that they were carrying and deciding those and putting the financial cases on the back burner.
And we have reversed cases in family for stale numbers, and we've sent it back and said, reverse, the court is to look at the recent numbers because it has been so long and it has affected one of the points on appeal. So you do want to be mindful of that, but then remember, as trial judges, that if we send a case back with direct instructions for you to just, not all of the case, but just to focus on the numbers maybe for your Form 14 because we say it was stale, that's all the trial court has the authority to do. So you can't go back and reopen up the whole case and then decide, oh, Judge, I know the court sent it back for you to use these fresh numbers, but can we now visit the fact that this child is now emancipated and I really shouldn't have to pay it any child support? Doesn't work.
Now, to get there, we'd filed a motion to modify
Exactly.
and just piggyback that on and off to the
Yes.
races.
I know we're about to run out of time, but let me just say, I have 20 copies of these surveys today. I know Mr. Berger said he's going to email you a copy if you want one of the surveys, and it has a lot of ideas about what judges want and do not want in their courtrooms. So I would suggest strongly for you to get those surveys. Thank you.
Thank you. Yeah, we'll keep copies of these. We'll have these 20 out there. We'll